happened?
That was from a little running accident the other day in California.
Oh, I forgot to ask you about it. Okay.
All right. Hey, everybody. Greg Siskind here, along with Lynn Susser and Ari Sauer. Hopefully, I don't know where we put the little thing where we could say our names on here. I'm going to see if I can find that. I know
it was on there until the weekly stream banner went up, and then it dropped off. It's okay.
We'll find it. Anyway, so welcome to our second weekly stream for 2025. And we're going to go through and talk about the major news developments for the last 8 days, I guess, because it's a week and a day. And then we're going to take your questions. So if you're watching us on YouTube or you're watching us on LinkedIn or Facebook or X/Twitter, all you need to do is post the question you have in the comments, and it should show up for us where we see it, and we can actually see your questions here, and it's all assembled in one nice place. Thank you, StreamYard. So let's go ahead and get started. I mean, we were trying to think, do we group these thematically? It seems like there's throwing a lot at us, but the big thing, obviously, I guess we'll start with enforcement. And so this was something the news has been covering, obviously, in a big way. And there are a number of items on our list that are in one way or another related to it. So, we had high profile raids in a lot of cities and made a lot of headlines. It resulted in sort of on further stories that were related to that. But it looks like, Lynn, you said you had some of the statistics for what we saw in the first week. Is that right?
Yeah. I was told that they arrested 5,000 people and detained 5,000 people in the last week, which is a huge number. A colleague of ours was told by an ICE officer, sort of off the record, that ICE field offices had been notified that they had a weekly quota of 75 people a week per office, which comes to, approximately 1,500 people a day. 75 people a day per office, which comes to about 1,500 people a day, or over 10,000 people a week. So that, begs the question, like, where are they going to put all these people? As of last Friday night, there were 39,000 people in ICE custody. Of course, most of those people long before the Trump administration took over, and they only have a total of 41,000 beds. So, the question is really like, where are they going to put people if they keep detaining them? So we can talk in a minute about those people that they can, pick up and deport quickly and don't have to be detained. But that's the issue.
Right. And so we saw, another story, and Ari, you guys are going to be annoyed because I'm going to go out of order a little bit, but I kind of want to stick to the theme. So speaking of where these people are going to go, one of the places that some of them were going to go was Colombia. And there were headlines around the world because the leader of Colombia told the U.S. military for 2 of their planes, we're not accepting planes as long as you're treating people that way. And they were all in shackles and basically treated like they were, like not a very nice
criminals.
Hardened criminals. And maybe there were some hardened criminals in there, but we know that a lot of the people being picked up are just ordinary workers and family members who have unfortunately gotten crosshairs with immigration law. But anyway, that created a whole stir where the administration had a immediate reaction to that, saying that they were going to, this is, I guess, the favorite go-to when you annoy the president, we were going to impose a 25% across the board tariff, and then a 50% if they don't start taking in people like a week later. I sort of was like, be careful what you wish for, Donald Trump, because we get Colombia is our number one importer for coffee. We get that, and cut flowers, and a whole bunch of other things. And coffee, there's already a global shortage of coffee right now, which is why you may have noticed that coffee has been going up at your favorite coffee places or at the store. And this is a guy who got elected because of egg prices. So, when you start telling people that you're going to lower prices on everything, and then you threaten the one thing that everybody in America has every day, which is a cup of coffee or a couple of cups of coffee. And you're talking about adding a couple of dollars a day to everybody's bill. Be careful. I have a feeling, this is just my conspiracy theory suspicions, that they probably worked out some kind of deal quietly for Colombia to, basically back off so that they didn't actually have to impose the tariffs, which they didn't really want to impose because of what I just said. So I don't know if that's true. It just feels true.
Well, and the truth is that Colombia's already changed their position. So somebody said something that convinced them.
Yeah. And anyway, and so some other countries right now are kind of saying similar things. The leader of Brazil, Lula, also got into a kerfuffle with the administration on the exact same issue this week. That one had to do with the flights not having air conditioning, and they were leaving people basically like on the tarmac for periods of time. And my understanding was the Brazilian military basically forced ICE or whoever to like let everybody off of the flight right then and there, and not do it in the way that they wanted to do it. Anyway, it was a mess. But that's apparently going to be a thing.
And so I would just jump in there and say that the other outcome of that whole Colombia mess was that the U.S. consulate in Bogota suspended all visa issuance and canceled all the appointments. And that's a consulate that typically issues about 1,500 visas a day between non-immigrant and immigrant visas. And they canceled all the appointments for this week and indefinitely into the future.
Right. And one of the interesting things was they didn't cite, normally, like they go to is to cite 212F, which is the entry ban language that they use to justify the travel bans. But they did this time in a different way. They cited another section of a law, and also, even though they, I don't know if they cited it or not, but they, the Laken Riley or Laken Riley law that just passed was actually signed by Trump yesterday, but it was after the Colombia ban was announced. But basically, that law says that countries that don't accept people back, that the State Department can impose bans, like we're now. So I am not sure if they're sort of like jumped the gun a little bit. I mean, I guess Trump could have signed this thing at any time, but that's one of the first consequences of that law, was what we just saw announced regarding Colombia. So I expect probably to see more of that kind of thing, where anytime a country basically resists to Trump, he's going to threaten both tariffs and visa bans. At some point, I have a feeling people are going to, these countries are going to say, go ahead on there and see, because they eventually end up punishing Americans by imposing those things. But we will see. All right. So that was, that knocks off a couple of items on our list. But there was also another announcement regarding detention, Lynn, which you had just like, where are these people going to go? And apparently Donald Trump thinks that they're going to send 30,000 of them to Guantanamo, where we've had basically, like 80 terrorists that have been there for the last zillion years. They don't have housing for 1,000 people.
Right, but that's not where they're going to send them. There is evidently a Navy base on Guantanamo that's separate from the prison where the 9/11 terrorists have been held. And on that Navy base, there is a detention center that used to be used for when ICE or CBP caught people, or the Coast Guard caught people at sea, Cubans or Haitians, right? But it hasn't evidently been used in some time and is in disrepair. But they say that if they cleaned it up, they could hold up to 30,000 people there, and they wouldn't do it as a permanent location, but it would be sort of a way station to take people while they're arranging flights to other places. So my guess that means, non-Mexicans, like people they can't just take to the border, but people who they need to arrange flights.
Right.
But again, that would require Congress. Even Secretary Noem said yesterday that would require Congress allocating money to actually be used to make the necessary repairs. And there's not even people there. Like there's no ICE staff there or anything at this point.
Right. And so speaking of Secretary Noem, that was another one on our list, which this is our new Department of Homeland Security Secretary, who was, the the bar is set so low right now as far as who gets confirmed, that she was considered one of the, despite all the craziness in the campaign with her admitting to basically shooting dogs and that kind of thing, she was considered one of the less controversial nominees. So she went through with flying colors. And we don't know that much about her, except that she was on some of those raids. She decided to accompany them for the photo ops, along with Tom Homan and who else decided to go along for the ride on that. But she certainly seems like she's just going to do whatever the boss says on there. But they do have a confirmed secretary now there, so that is part of the news.
Right. And one of the first things she did out of the box was cancel the TPS extension for Venezuela that President Biden had ordered a few weeks back before the inauguration.
Yeah. So, I mean, basically what they're trying to do, I think, is figure out how to turn legal people into people that are in illegal status on there. And you do that by revoking parole programs, revoking TPS programs, and basically leaving people in a position where they don't have a status anymore. And then you can say they're criminals. They don't have, they need
invaders.
Right. They need to be reported like everybody else, even though there's a lot of people who came legally and have been in legal status for a lot of years. That's how it's happening. Now, with that said, the TPS program being taken, revoked, the extension for Venezuela, it is worth reminding people that this is not new. Trump tried to do something very similar in his first term with some of the Central American countries, and he was unsuccessful. Why was he unsuccessful? Because there's a process that you're supposed to go through when you terminate a TPS program early. You are supposed to show that there are dramatically changed country conditions that no longer justify it. Otherwise, you could be accused of violating the Administrative Procedures Act and doing something arbitrary or capricious. So that is, I am guessing that that's what we're going to be seeing. I don't know of any litigation yet. Maybe we'll consider it. I'm not sure, but I'm guessing that that's going to be litigated, probably by the same people that litigated the last time, and probably they'll go back to the same judge. The judge and that court may end up assigning it to the same judge because it's a related matter, it's a related issue on there, which sometimes happens. So we're going to see this theme over and over again of courts intervening on some of the overreach, and we have a couple of examples of that this week. So last week when we were talking, it was it Tuesday night or Wednesday night? It was Wednesday night, I think, last week. And we had the birthright citizenship was the big news, and we said, just take a breath because the courts are probably going to step in on that. And then I think it was later, it was even the same night as our live stream, like later that night, that the news broke that Washington State, the district court in Washington, a Reagan appointee, not a Democrat appointed judge, had said that the executive order was blatantly unconstitutional. So that's not a good sign. This is the beginning of it. It's an injunction, but they issue that when they think there's a pretty strong likelihood that the person, that one side's going to win the day, and that was obviously that was the case. I thought an interesting aside. Our good friend Cyrus Mehta wrote a very interesting opinion piece this week about this subject, about how can the Justice Department just go along and file things that are blatantly, make arguments that any reasonable person would say are blatantly unconstitutional? And the answer is they're not supposed to. On there, they are not supposed to just follow orders. They have an obligation they take an oath when they are sworn in as lawyers, that they are going to that they're going to to the Constitution and the rule of law, and that they're going to act ethically. And there are a couple of ethical rules that come into play when potentially when a government lawyer just goes along to get along at their agency. And I'm only mentioning that. I don't know if any of them are going to be watching this live stream, but you need to be cautious about your law licenses and bar complaints being filed if you do things that are not defendable on there. So hopefully you can make the arguments that they are. But it is something I would. There's a lot of young lawyers who go in the Department of Justice, and they're nervous about what they're being asked to do, and at some point, you're going to have government lawyers are going to have to make judgments for themselves. If I file this, am I potentially violating my ethical responsibilities? Am I putting my law license, which I'm going to need for the next 40 years, at risk by filing this thing on there? And I would say that's something that they need to consider. So that's just a thought, but it's something that I hope that some of these lawyers will think about before they file things that are, morally objectionable, but more importantly, constitutionally objectionable or violating other rules. All right. So with that said, the other program that was also announced, that it was a shutdown it was more like not taking any new people in from abroad, but the Uniting for Ukraine program also, there was an announcement that they have stopped accepting those applications. And I think was it the I-134A is no longer I think that's kind of how they made the announcement. It's like, we're not taking this anymore on there, which means that they're not taking those applications anymore. Mm-hmm. All right. So back to this thing. So we have this birthright citizenship order, and Lynn, I want to kind of let's talk about court again, because there was another, series of developments that seem, are not really directly immigration things, but they affect immigration. And these are the AI executive orders that had to do with hiring freezes and forcing people to go back to work 5 days a week, and other changes that are designed to put a lot of pressure. Oh, and the new one today, it's not an executive order, I think, but this announcement that we'll give you 7 months salary if you quit your job on here.
Right.
So
8 months salary.
8 months, yeah.
8 months salary.
That was in an email that was sent out to all civil service workers in the federal government yesterday, all federal employees.
And I've seen that it has been, it's they didn't say who got it, but I have seen where it's been said that the USCIS officers have received it. The immigration enforcement, ICE and CBP, I'm assuming, I don't know if it's all of CBP, but are exempt from this. They're not going to get that offer. Yeah. But it has been rumored, at least some people have said that they've been told from immigration officers, USCIS officers, that they received the letter. So it looks like it's going to affect USCIS. That was one of the questions that came up.
Before you even get into the comments on that, this is a bait and switch that Donald Trump is doing on the federal workforce. A court is going to shut that down, just like they shut down Joe Biden's student loan initiatives, and probably for the same reasons. It's not allowed. Congress authorized money to be spent on these workers. The president can't say, I'm going to spend all that money, but I'm not going to ask you to actually do the work for it. It is going to be thrown out in court, and all these suckers, and that's what they are, if they follow along with that, are going to quit their jobs, and they are going to get nothing. They are going to basically, for the rest of their, for the rest of that period while they're looking for a new job, and they quit, so they're not going to get unemployment. Those people are, they're going to find themselves in a very bad spot. So anybody, hopefully, that is thinking this is great for me, good luck on there. So Lynn, continue on.
Yeah. So I think that 3 things happen that affect sort of the size of the workforce of the agencies that we're dealing with, and primarily the benefits agencies, because as Ari said, I don't think they're trying to get rid of anybody who's in enforcement. Right. But USCIS certainly, and probably the State Department, maybe even Department of Labor, OFLC. So 3 things happened. One was the the hiring freeze, right? They said there was an automatic hiring freeze until OMB could come up with a good plan to shrink the federal government. And if they don't do it in 90 days, the freeze continues. The
Right.
second order had to do with a mandatory return to work policy. And I don't know exactly how this is going to be implemented, because there were large swaths of people who work at, especially at the USCIS service centers, that have been remote for many, many years before COVID even. And they don't even live in the areas of the service centers, or not in, rural Vermont or rural Nebraska. And they were already understaffed. So I don't know how that kind of remote work, that kind of workforce returns to work. And then of course, the third thing that happened was this email that you talked about that went out offering them a buyout. So I think that the ultimate result of all those things is that we're just going to continue to see shortages, which leads us to a couple of the questions that are here in the comments. There's one question here that asks, how is this going to affect my NATS process? Well, I think the way it's going to affect your NATS process is the way naturalization applications are adjudicated is they get filed electronically or by paper at a service center, but then they are sent to the local field offices for interviews. And there's, the less people to adjudicate, the less people, the longer it's going to take to get those applications done. So I think we can probably expect, some delayed processing times. The other question here was, there's a comment in here that says today marks, by Daniel Lopez, it said today marks 31 months of waiting for approval for my 601 waiver. So you're not alone. Average processing times on waivers right now is about 3 years. So you probably even have a few more months to go. And obviously processing times aren't going to get any better if there's even less people to adjudicate. So I think that the lesson from all that is, so he's saying, is that why USCIS processing times continue to increase? Absolutely, that's why they continue to increase, because they're already understaffed. I think we mentioned it last week on this, in this conversation, that we're already seeing, delays on premium processing cases that are not being adjudicated in the requisite time and are therefore being kicked out of the premium processing queue and put into the standard queue, which basically gives them as much time as they want. And then of course, there's all the different things that aren't even subject to premium processing, which are taking a very long time already. So I think that, these different actions they're taking are going to really accomplish exactly what the administration wants, which is to have a smaller workforce, of course, but also to slow down the adjudication of people's, green cards and citizenship and immigration benefits.
All right, so we have just a couple little items that are worth mentioning, and well, it's not so little, but Ari, we have been hearing reports about anybody with the word parole in their status seemingly having problems at ports of entry, even people with advanced paroles that are tied to adjustment applications. I've heard some reports that people have been getting, seeing problems and being told that they have to enter in one status or another. So can you tell us a little bit about like what's going on, or what we're seeming, if there's a pattern that people can take from this as far as like things to at least be monitoring?
Well, we think that this is just a result of the executive order that's calling on the ending of parole programs for general groups. And by the way, there was a question on here if whether or not the Afghani parole program is affected. And the answer, I believe, is yes, because it does include the I-134, which is no longer an option. So it's what it seems is that the CBP officers, not having received yet any guidance on it, as far as we know, are now saying, the paroles are all in question. But so far it's only been, some here, some there. So it does not appear that it's across the board. But we are advising that those with parole hold off on traveling if they can avoid it until this is figured out.
And there's a question in the chat about that, Ari. There's a question here that asks whether or not we think this is going to impact people, filing on advanced parole with employment-based adjustment applications. And I think that's exactly what we're saying, right?
Right. Well, what we're saying is that the order does not officially affect
right,
that.
right.
Because
Just
the executive order was only for parole programs for various groups, which doesn't seem to have applied to those with I-45. It seems like those programs for Ukraine, for Afghan.
It's not supposed to affect.
Doesn't seem
I-45.
CBP. It seems that CBP is confusing humanitarian parole with advanced parole, which is a completely separate thing. But in this moment, it sounds like they don't. At least from what it sounds like, the clients are reporting back the conversation that they had with CBP. It sounds like there's confusion about this. And
I'm not aware of anybody.
And they say they've had no direction
yet.
I think this is I was going to say, I think the takeaway from this is there are things that are written and we interpret based on what they are written to say. And then there are the way things are playing out in the field with people who don't concern themselves so much about what the writing actually says versus what they want to do. I think the takeaway here is that we're hearing reports about some of these problems. Some of it might be the initial Trump euphoria that some of these officers feel. And what we did see the last time were we had all kinds of reports right after the election when it was still the Obama administration, but we were actually hearing reports about problems that started right after that, but that it did kind of settle down. Not that things were so peachy for the rest of the Trump administration, but it was definitely more problems for the first couple of months with people that were not following procedure. So I'm hoping that, these reports will be less and less common as time goes along. Now, of course, we'll continue to see all kinds of policies pushed out that are just going to change the written rules. But for right now, I think our advice is pay attention to what the written rules say, and then pay attention to what is being reported that's happening beyond that. And this is when we're saying this is happening beyond that. So just be cautious for a little while about that. Is that fair?
Yeah. And another just advice is if you are traveling on advanced parole, just plan that you are there's very possible you'll be put in secondary inspection, or just assume that that's a possibility while they go through and verify that your parole is still valid.
Always a good idea to give yourself a long connection at the airport also.
So that's what you want to be doing. Give yourself a long connection. Assume it's going to take a while to get through immigration if you're coming in on parole, at least for now.
Yeah.
Hopefully we'll hear more soon and this will all be clarified and cleared up. But
all right. One thing that I put on two things. So I put also on the list the AI executive order being revoked, and I think somebody actually asked a question about that. So the Biden administration issued a fairly broad and well-received artificial intelligence executive order that mostly dealt with things that more, they're interesting to me, but they're not really immigration things. But there was an immigration section in there that talked about making changes to the immigration system to facilitate the entry of workers that were doing machine learning and all kinds of other things that related to artificial intelligence, and changing up O1 rules and changing up J1 rules and all kinds of other things that could facilitate companies recruiting those workers. So as he did with a lot of Biden, I don't know if he got rid of all the Biden executive orders, but it felt like he did. But that one for sure he got rid of. And they, people were like, well, aren't there's some parts of that presumably you agree with. So what happens now? I will tell you that a lot of those changes were already worked their way into the USCIS policy manual. So the USCIS is going to have to either, they can leave them in, if the head of USCIS and the White House says leave them in, they don't have to issue another executive order saying add those in, add it in again. They can just do nothing. But the Trump administration, I guess, just did another artificial intelligence executive order that sort of was, wishy-washy, aspirational, saying that we should strive to do this and strive to do that, and they should be presented with policies. So it is possible they will, as they have a pattern, this pattern to do, is denounce the previous executive order, denounce the previous administration, and then roll out something that's almost identical to that, and say that, look at this great idea we just had. So we could see that, but that's for right now. I'm not anticipating any of the changes that were made in the policy manual on AI workers being taken away. And we've also sort of seen the one piece of news that we're not reporting, which is the no news. We have not seen, I mean, if you've noticed, we haven't really said anything tonight about any of the non-immigrant work visa programs. And that's because there haven't been any announcements. And I don't know whether that's because they're kind of saving them for the next couple of weeks or planning on rolling them out later, or they're afraid of all those Silicon Valley people who attended the inauguration, who have, they've upset all the workers at their companies. But so far, the immigrant workers can at least, be relatively comforted, but they seem to be leaving those companies alone for right now. That's not to say the situation is so great. They haven't done anything, for example, on country quotas or making it, increasing somehow the green card numbers that we're going to see. Nothing on that, but they haven't announced any of the kind of awful stuff for those workers that we saw in Trump version 1. So we will see. I had one little thing on this list that Lynn and Ari were kind of like, why did he put that on there? And that's so there's this court. Well, it's an administrative court called Okaho, and this is, I forget what OCO stands for, but this is the Department of Justice office that investigates I-9 violations and employer compliance violations, and they slap big fines on companies that are violating I-9 rules or discriminating against workers. And they actually issued an AI advisory. So any of the lawyers that are on this live stream that do anything in front of Okaho, just be aware that they are. They stuck it in an actual case, but just sort of as an aside. But my guess is they are feeling, and somebody must have done something. It could have been somebody on their side, on there. It did something with AI that got people worried over there, or somebody read it, went to a CLE and decided they were nervous about it. So the lesson of that is they are aware of issues about hallucinations in AI. And if you are going to be filing papers with Okaho, read that and just make sure you're using responsible legal research products for any AI related content that you're generating. So that was the last thing I had.
I believe that really comes to affect all administrative court judges. So that includes.
It is a good lesson. It's a good lesson to use on anything you ever file with a government agency, right. Which is, you are a lawyer. You have to read the cases that you are citing. You have to be sure that what it is putting out and what you are cutting and pasting into your documents are actually existing. And there are lazy people out there who cut and paste, and they don't actually check citations and check the original sources. And it's going to get more and more lawyers into trouble. So that's that. And if you are a client of a lawyer, you should be asking every once in a while on there, did you, if AI helped you with this, great, and hopefully, but did you, what can you tell me to assure me that it's being used responsibly at your office? And they should have some kind of policy or something that they can state that says that they are reading the cases and they are minimizing any mistakes that it's making. So that's all I want to say on that.
I think that's also a reminder that the AI is not a substitute for a qualified attorney. For
right.
Those who don't have attorney use AI, it's not the same.
It can make your attorney better, faster, and maybe less expensive in some cases, but it's still not
You still got to do the work.
Yes, you still have to be the lawyer as far as the lawyers that are actually using it, but it can make life easier. And obviously, we are heavily into AI at our firm, and pioneering on it. But we drill that into people about how to use it correctly. All right, so those were the developments. Do you have anything else that we want to add to the list of the news?
No, there are several questions I'd like to answer that are in the comments.
Okay.
That go back to what we talked about in regard to government staffing. There is one comment here that said that
If you
the
tell me
resignation.
Who it was, I'll put it up.
Yeah, so Taylor Linville is just saying that the email that was just telling us that we were talking about those emails that went out to federal employees. She said that everyone at the BIA received one as well, which is interesting. There was there's two different questions in here that have to do with I-751s and whether or not you can travel internationally with the 751 receipt. And I think the answer is yes for now. I mean, the receipt notice of an I-751, which is a petition to lift the conditions on a green card, on a conditional green card, has language in it specifically that says that it's for travel. And I don't anticipate that that's actually going to be a problem. I think that people will be able to travel with that and, their valid passport and be fine. There's a question here that asks about perms getting delayed. So, OFLC, which is the Office of Foreign Labor Certification, which is part of the DOL, which handles perms, is already like incredibly understaffed. So I do think that we're going to see long perm delays, regardless. I mean, regardless of whether anybody takes the resignation, I think they just already have serious problems over there. They're doing the best they can. There is another one that just talks about USCIS processing times. And I think that's just what we were talking about before, which is they're going to, increase. Manu is asking a question, will employment-based I-485 interviews still be waived? As of now, they are being waived. But, this is something that happened during the first Trump administration. It was sort of one of those roadblocks that was thrown up to slow things down. So, wouldn't be surprised.
They are not.
I am not expecting
at USCIS offices. They're not begging for this to happen.
No.
Again.
But I don't know. I'm expecting, based on what happened last time, I am expecting them to make us have to go through interviews again, just like they did last time. I think they're going to require interviews for the family-based cases that a lot of which have been waived, for the 751s, a lot of which have been waived, and for the employment-based cases, I think we're just going to see a lot more interviews. For the reason, I think that's going to be part of their extreme vetting that they do, and I'd be surprised if that doesn't happen, honestly.
I think you're right. And I think they're going to use extreme vetting as an excuse. But the reality is that they, their goal has always been to slow things down as much as they can so that less people get green cards and less people are naturalized, or that it takes longer and longer. And so, mandatory interviews for everybody getting a green card is a good way to do it because it's very effective. The local field offices, only interview a very tiny fraction of the people who get green cards every year. And so to make it mandatory for everybody, we'll just flood those offices.
So I've just put up a question about something.
And I just want to add to that. And it'll also currently, in order to save time and improve processing times, USCIS has been sending cases. They'd be going to local offices, even though it's not the local office where the person be interviewed, because that local office has officers that can handle it, for example. And if they require interviews for everybody, that process is going to change, and then you'll have major differences. Although there are still differences, but you'll have even more so major differences between whether you're being adjudicated in one case, one town or another, will make a huge difference in your time frame. So that's another.
Also, and the other thing is that you end up having employment-based applications adjudicated by examiners who are not used to doing those kind of applications and aren't familiar with the issues. This question here is talking about DACA.
Yeah. So what do we think is DACA going to have any, I mean, obviously the Supreme Court has it on its list, but is there any changes that we expect for the people in the DACA program right now on how their paperwork is going to be, other than this general theme of everything's taking longer?
I mean, I don't think
mean,
so
we've
right
been
now,
advised-
because
Sorry, go ahead.
it was court ordered with the current process that we're under, in that the government has to continue to accept renewals for those that have it, that they don't have to accept new applications.
That's not the question, though. The question is,
Right, the question is
how are they
processing.
going to jerk people around and still comply
Yeah.
with the court order?
So
Well,
I wanna
how are
say
they going
one
to
thing
put? They're
about
going to
this.
end paroles.
Right. I think that's right. I think they're going to stop issuing advanced paroles. They did that last time. But I would tell you one thing, Aileen, the DACA renewals are going very quickly right now. And I would advise you to go ahead and just file an extension, because you'll get a 2-year extension. It might get you to February of 2020. You know, it might get you a little bit further along. It might get you now, if you file now, till February of 2027, because at whatever point they approve it, it's only going to be approved for 2 years. But it seems to me that since 2012, when this program went into effect, that for whatever reason, USCIS officers like it. And they have always, throughout both administrations, have fairly quickly adjudicated DACA renewals. And every time there's sort of been on the horizon that it might end, they've sort of quickly adjudicated whatever they had on. So I don't know. It's just me, and I could have just dreamed this whole thing up. But it feels like USCIS examiners are compassionate to DACA, and they're sympathetic with it, and they tend to adjudicate them well. So I would, if I were you, just go ahead and file a new application right now.
Right. I just want to add, though, that even though we are seeing right now that they are adjudicating those quickly, don't delay in filing your extensions, especially if you are
do it as soon
anywhere
as
close
possible
to doing it, because not every case is adjudicated quickly. So don't delay in filing your extensions.
And we also don't know at what point they're going to try to make them stop. But I would just say, for now, go ahead and do it.
All right. So this question I'm kind of trying to interpret, because I think I know what they're talking about.
Okay, so
right,
then I'll take this one. Okay, so what happened during the last Trump administration? There wasn't a canceling of wage one H-1Bs, because that's part of the regulation, and I don't think they can. I mean, I don't see that they're even going to be able to try to do a canceling of the level one. So just to explain for those who don't know, there are 4 levels in the Department of Labor's prevailing wage listing, okay? With level 1 wages being for entry level positions generally, and level 4 wages being, the top level. We were experiencing for a bit there, our requests for evidence on cases that had a level 1 wage, where they were questioning whether or not level 1 wage was appropriate for that, saying the level 1 wage was not appropriate. So it's, they can't cancel the level 1 wage. I mean, they could try, but I don't see how they can legally do it. But we could possibly end up seeing those requests for evidence again. I don't know what everybody else's experience was, but generally, in my experience, was we were able to overcome those. Past experience doesn't guarantee future experience, though. So, is it something that we could see in the future? That's very possible, but it also was something that it only happened for a period, and it didn't last the entire administration, and they stopped doing that after a while.
Well, I think we all as lawyers learned how to address it, and we just started addressing it on the front end when we were using a level 1 wage. But one thing I will say is that when the OES, or the Department of Labor, updates their prevailing wages every July, the first week of July every year, they get updated. And this past year, when they updated them in July 2024, they really increased them a lot. And so the wages levels right now are, in some areas, are extremely, extremely high, and dramatically higher than they were a year ago, and unjustifiably so. So I can see where people may try to squeeze things into level 1 where they aren't appropriate. So I think that that's probably the lesson here, is that we need to be really careful and only use level 1 where it's appropriate. So where we can justify it as a entry level job that doesn't require anything other than an education and no experience. But I think that in that sense, we're going to have issues with wage levels.
All right. We got a question on student protesters, I think, and we actually had a discussion internally today. So there is not an actual change that was announced today on student protesters, except just the basic. I mean, I think what the administration was just doing is just putting people on notice that we're collecting information and we might do more later. And if a school, has something to report and see this on something that conceivably violates where somebody is violating the law, they are to report that. But I don't want to tell people it's like nothing's going to happen. I'm just like saying at this point, it's pretty vague and there's nothing specific that we can advise on that, just to keep an eye on that. With that being said, obviously this administration has said on a number of occasions that they want to crack down on student protests. So, just keep your eyes on that. But that's really, I think, all we can comment on that. There's really nothing. There's not a concrete policy change that we can point to right now, other than what we just saw in one of the executive orders where they said that the Department of Education is going to basically start some kind of database and monitoring, however vaguely ominous that sounds on there. So we may have more to say about that as it goes on, but I did want to kind of like not ignore that question. There was a question about the 90-day rule for adjustment of status being brought back. When was the 90-day rule that they would do?
I'm not sure either what that's referring to.
The 90-day rule, they're talking about someone who enters on a non-immigrant visa.
Oh,
they're saying you have to adjudicate an adjustment.
Did it go? The 90-day rule didn't go away. I mean, it's still in effect.
Yeah, I mean, that's what I can tell you. So just to give a little background, the last Trump administration, there had been some changes where it made it sound like they were going to crack down more on people that entered in something like a visitor status, for example, and then applied for adjustment of status really quickly after they got here. And, we haven't heard anything this time about changes happening on that particular issue. Now, that's not to say that, they're not going back to the golden oldies from the first Trump administration, from time to time, but that hasn't shown up anywhere in anything I've seen, either in Project 2025 or in the regulatory agenda or anywhere. So nothing.
Just to be clear, the policy is still in effect. It never got. I mean, that wasn't.
Also,
it's still in effect. It doesn't affect certain types of cases, but
right.
No, there is still the policy of.
I also would point out that it's the kind of thing that is sort of dependent on adjudicators, right? Like it's not the kind of thing where the mailroom looks at your application and says, oops, you filed too early and they reject it. It's the kind of thing that only arises later on when the adjudicator is looking at it and looks at your immigration history and then makes, has some questions. So it's not the kind of thing I think that we're going to like see that's going to become like super obvious. We're just going to either hear about cases where it's, where it's being upheld or not.
And just to explain that, I don't think I went through explained it. The 90-day rule is that if you enter on a non-immigrant visa, like a visitor visa, student visa, those are going to be main ones. They're going to have this issue.
Visas that require you to have non-immigrant intent.
Right. Those, if you enter the U.S. on that visa and then you apply for adjustment of status, you apply for a green card within 90 days of coming into the U.S. on those visas, then there is a presumption, or the officer is allowed to have a presumption that you had immigrant intent, that you had the intent to come in and you intend to apply for adjustment of status when you came in, which is a problem. But it's a rebuttable presumption. So, as Lynn was saying, it's not an automatic thing that it's going to be an issue. In other words, if you can show that something changed after the fact, then that's where you're at. But and also, I just want to point out that because of certain court cases, it's not as much an issue when it comes to immediate relative categories. That's U.S. citizens, spouses of U.S. citizens, parents of U.S. citizens, and children under the age of 21, unmarried children under the age of 21 of U.S. citizens. So if you're filing under the immediate relative category, that's not as much an issue. But it's not and we may see more enforcement of that rule, more use of that rule. Sorry, but the rule has been there, so it's not a question of the rule coming back because it didn't go away since it was put in effect.
All right. I added this question on here because I think it is a good sort of just question about that nothing has been announced on anything that affects this particular issue about marriage-based green cards being scrutinized. But it's sort of like, it is one of these things where you should just assume that more scrutiny is going to be put on anything where there's discretion involved, and it's based on your credibility, that there are people that are going to feel like they can get into trouble by saying yes. It's easier for them to say no. And, so I would say that just in general, just be better prepared, be better prepared for the interviews, be better prepared as far as the evidence that you submit on your cases. Don't take anything for granted as far as, saying, well, I don't have a lot of time and this should be good enough, and I know my case is fine on there. You should just always be thorough and have as much documentation. But this is one that even before Trump, you should still be
right. That's what I wanted to say. Is
that's what I was saying too.
Marriage-based green cards are always heavily scrutinized. So while on the one hand, it's the easiest way to get a green card if it's a bona fide real marriage, on the other hand, they are always heavily scrutinized in all offices. And so different offices have different practices in regard to things like separating you in interviews and things like that. But they're always looking closely at the evidence. They're always being a little bit cynical about it. And so, like Greg said, you need to be prepared for these cases and they need to be well documented. And this is the kind of case where it's really good to have counsel, because they can tell you, especially local counsel, as to what's the field offices are looking for.
And I want to reiterate what Greg said, that Greg, I don't know if you realize how important, a lot of times, people get in trouble because they think, hey, it's a real marriage. We're really married. It's obvious to me that this is a real marriage. So why do I have to jump through all these hoops? And again, just because it's obvious to you does not mean that it'll be obvious to an immigration
officer. People, it's always the man, whether it's the man is the immigrant or the man is the U.S. citizen, that has the trouble because they don't pay attention to anything in their life on there. They have no idea what the color of their carpet is. They have no idea what brand of toothpaste they use on there. So the men usually have to work a little bit harder to make sure that they are paying more attention.
Well, that's true. And that's true in interviews. But the other thing is, it's always the U.S. citizen who thinks that less documentation is needed, because it's always the U.S. citizen who thinks, of course, it's a real marriage and this is my government and I'm not afraid of my government like people are from other countries. And so this is enough. And so, it's one of those cases where more documentation is better than.
When it's an issue, they hear, does my government hate me? Your government doesn't hate you. Your government doesn't even know you. But again, they've been scrutinizing up until there hasn't been a lessening of scrutinizing the cases. And again, it often just depends on the officer. But don't take anything for granted. Your marriage-based case has to be documented.
Anyway, I just thank you, Robert, for acknowledging about the 601A. They are all done. We are actively discussing new issues that we want to litigate. It seems like there's a whole smorgasbord of things that to upset us in the new administration, but that is something that our firm works in conjunction with our litigation friends at Cook Baxter and Joseph and Hall and Jesse Bless, and we'll probably be getting back to the live streams on that fairly soon also. I wanted to, so there were a couple of questions regarding people that had, this is, I think, an important question. So for those that are in these programs that are being canceled, what are their options on there at this point? So one of them is they mentioned the I-130. Obviously, people should talk to counsel about whether they have a case for asylum, maybe that can be filed. I mean, there's a lot of options that might be out there, but
No, I think
would,
that's not this question, Greg. That's not the question here. The question here has to do with the parole in place that was available for a minute, or
for the,
was supposed to
for
be
the,
available for a minute
right, for the
for
country.
spouses of U.S. citizens, And so they started that program and then they canceled it. So I think
Well,
what she's
there
asking
was,
is it, should we go
okay,
ahead
yeah,
and
'cause
file?
there was also a program for people in the back that were family applicants from Colombia and a few other countries.
Yeah,
as
that's
well.
not what she's talking about here. She's talking about whether or not people who were eligible for that. So so the people in that group that were eligible for the parole in place were specifically spouses of U.S. citizens. And
Right.
so for
Apologies.
spouses of U.S. Yeah, that's okay. No, so for spouses of U.S. citizens, I would say the answer is probably you should go ahead and file an I-130, but you do want to go speak to counsel, because you need to make sure that if the whole point of the parole in place was to give people a legal entry. So presumably that means we're dealing with people who are married to U.S. citizens but did not enter legally. So that means they need waivers. So I would suggest that in this case, and that means they're going to have to consular process. So go talk to counsel so that they can look at the very specific details of your case and make sure that there's nothing that would bar you from admission if you had to go out, I think is the answer. So I wouldn't say there's just a blatant, like, sure, everybody go file. But in most cases, if there's nothing to bar you from admission other than the 10 years of physical presence, then, which is waivable, then probably the answer is sure. Go ahead and get that process started.
And kind of related to that question, one of the questions is, can the administration do away with the ability to fix immigration status for parents of U.S. citizens with legal entry? So this is, this relates to all the immediate relative categories. Again, includes parents of U.S. citizens, spouses of U.S. citizens, and children of U.S. citizens under 21. The rule is that if you entered with inspection and admission, okay, quote unquote, legally, then you can, and again, there are other factors, but you're able to apply for adjustments as apply for a green card here in the U.S., even if you're out of status. Okay.
Right.
Now, again, there are other factors that come into play there, but no, that is part of the statute. That is not something that the administration, that would require Congress to do away with that ability.
Following with Leslie's
Right. So Leslie's
So that's a good question. Yeah. So that's a good question about the U visa. So, the U visa process, U visas are for people who are victims of violent crime. So people who, and the U visa process, because there's a 10,000 cap each year, is very oversubscribed and the process is very delayed. But the way the process works is you file for a U visa, and at some point, and I think it's taking about 2 years right now, you get sort of a provisional approval. That basically means immigration looked at it and they say that your case is approvable, but they can't actually approve it yet because there's no visas available. So what they do is they allow you, with this provisional approval, to apply for work authorization. My understanding from a lawyer I heard speak yesterday was that in some areas, ICE is considering people who have been in the United States less than 2 years, who are then, of course, eligible for what we discussed earlier, which is expedited removal, are picking up people with U visa applications that have provisional approvals but don't have U visas. But that only applies to people who, again, have been here for less than 2 years. And I don't think you can get a provisional approval in under 2 years, because you had to have been here long enough to have a crime.
Let's talk about the 2 years, because we talked about that before the call. That's one of the most important things that people need to know right now, which is that they are trying to bypass having to put people into immigration proceedings, removal proceedings in court, because it is a super long backlog. The odds are really good that this Trump administration will be over by the time your case actually gets in front of a judge on there. They do not want you to go to immigration court. They want you to leave the country on the first flight that they can put you on. They can only do that for people that have been here for less than 2 years. However, they don't think, they're not giving you the benefit of the doubt, as far as if you just say, well, I've been here, 5 years on here, they will still prove it. And they are, and how do you prove it when they just picked you up in your car after you had you were driving without a driver's license, or, however your encounter started, or your work site got raided or whatever. the answer to this question is you have to have documentation on you at all times, whether you're going to church or you're in a hospital or you're a teacher in a school or whatever your story is, that documents if you are in a status and how long you've had that, or at least how long you've been in the United States. Lynn, what kind of documentation would people, could satisfy that if they encounter that?
Right. So, as Chris said, people who have been here less than 2 years are subject to this thing called expedited removal, which means ICE can remove you without a hearing. And so, in Aileen's case, just to backtrack for 1 second, Aileen, I'm sure your parents have been here longer, so your parents should do what we're talking about right now, which is carry proof with them that they've been in the United States for at least 2 years, more than 2 years. That can be their kids' birth certificates, a marriage license showing they got married in the U.S. ages ago. It could be, it could be bills. It could be a lease on an apartment or a mortgage on a house. There's all kinds of things. A driver's license that was issued, more than 2 years ago. A Mexican passport that was issued at a Mexican consulate in the United States, more than 2 years ago. So there's all kinds of documents that you have that you can sort of quickly produce and show. And
Not
the
that
point of
different
that
than
is
DACA. Not that different than what we had to do in DACA, where we had to have documentation.
Right,
about
that's right. But you don't have to have that much. You just have to have enough in your on hand that you can stop an officer long enough to show them that you've been here. And so anybody who's in the U visa process has been here longer, because it just takes that long. First of all, you had to have been the victim of a crime. So you had to have been here long enough to be a victim. And then you had to have been here long enough to actually get an application filed and whatever. So that all being said, if you have only been here a very short period of time and you just have filed a U visa application, but it hasn't gone anywhere, you're removable. You're still undocumented, and just having that application pending is not going to save you. So there are, besides people that have been here less than 2 years, the other people that are easily removable and seem to be the focus of ICE raids are people on parole, because people that are on parole are technically haven't been admitted. In a way, they've been admitted and they've been inspected, but they have different rights than other people. People with final orders of removal, people on orders of supervision with or without ankle monitors, recent arrivals, and then finally, there's the people that just get turned over to them from law enforcement. And there's also another easy group of people are collateral arrests. They go out to pick up one person, and there's 6 other people sitting in the living room or on the job site or in the restaurant or wherever, and so they just get them all. So this is what ICE considers sort of to be low-hanging fruit, right? It's easier for them than having to stage a big raid. So that's why it's really important for people to do just what Greg was saying, which is carry proof of either your status. If you have a status, carry evidence of it, right? If you're on an H-2B or you have a visa or something, make sure you've got evidence of that with you, a copy of your I-94 or your work authorization card or whatever it is. And at the same time, if you don't, have proof that you've been in the United States for at least 2 years, so that they have to put you into removal proceedings and give you an immigration hearing.
So Aaron Hillis was asking a related question to this, Lynn, about people that are in legal status, like Fs and Js, whether they should carry. And I think the answer is yes. I think everybody, because the burden is, they've essentially putting the burden on the foreign national to prove that they are in a that they're in a status and they're not subject to it. And we know from these raids that just happened, like the ones in New Jersey, U.S. citizens ended up on those airplanes, and they pay, which is crazy. Puerto Ricans who are U.S. citizens at birth were put on those airplanes, and they're not doing a whole lot of scrutiny. It's like deport first, ask questions later.
Sure, it's not a bad idea for U.S. citizens to be carrying some ID too.
Yep, it's racial profiling. If you speak with an accent or speak another language or look like you might be a foreigner, it's better just to have documentation in your pocket. You don't have to carry your originals, but keep a copy of your U.S. passport or a copy of your green card or something with you at all times.
Or if you have a real ID, qualifying
driver's
ID,
license,
like a real ID driver's license, that should be sufficient.
Mm-hmm.
Yeah, that's true.
Sure. Yeah. So.
Yeah.
Yep.
All
better
right,
to be over prepared.
So I think we're going to wrap it up because we wanted to kind of cut it off in an hour. We'll be back again next week. But I think next week, one of the things we were going to talk about tonight, maybe we'll talk about it next week, are employers and how they can prepare, if they are, how they can prepare their workers, how they can prepare themselves for any enforcement actions that might be coming. So hopefully we'll get to that next week. But anyway, we got a lot of questions tonight. Hopefully it was helpful.
And if we didn't get your question tonight, we might, hopefully we'll try and get to them, address some of them next week that weren't able to get to today.
Yeah, and we will. This is recorded, so you can, if you came late and you want to see kind of what was happening earlier in the conversation, you could watch in any of the places. The place that you're watching it right now, it will be sitting there, but you can go to YouTube or the firm's Facebook place. Anyway, so thank you, Lynn. Thank you, Ari. I'm Greg Siskind, and we appreciate your attending our live stream. We'll be back next week. Bye.
Good night, everybody. Thank you.
Bye. Lynn already left. All right.
Yeah.
Sorry.